Judge Trapp, would you go first?
Well, I think as long as we continue to elect judges in a partisan system, then the voters need to have more information about judicial candidates rather than less. And I agreed with the change that was prompted by a Sixth Circuit decision, a change in the ethical rules that allowed judges after the primary to announce what their party affiliation is, because it's just one other bit of descriptive information about a judge. You learn that I'm a Democrat. You learn that I'm a Catholic. You may learn that I'm a competitive skater. All of those things in my background will help you give some idea where I came from. But I am not going to comment on whether the law should be changed to put D's and R's on the ballots, because that is now the subject of pending litigation in the Southern District of Ohio.
Thanks, Judge. And Justice, your thoughts?
Party label is one fact, but it's certainly not the most important or most relevant when voters are looking at an individual to run or to serve them on the court. We do not decide cases on party lines. Once we go on the bench and we put on our robe, we are not Democrats, we are not Republicans. We don't look at cases with Republican eyes or listen to them with Democratic ears. There's no agenda to advance. We don't represent a specific group. That's very important for people to understand, that we are justices for all. And the comment about diversity and needing diversity on the court is really a red herring. We certainly now have an individual, Justice Pfeiffer, who has been an attorney for 25 years. If you look at the court and you say, well, there's no one from Southern Ohio, there's no one who is African American on the court, I think a candidate with those qualities would bring a diversity to the court. That's why it's a red herring. You should look at the philosophy of the individuals who are running and their experience when you're determining who to select, not simply party label.
Thank you. And now we'll have some announcements. Today at the City Club of Cleveland, we are listening to a debate between Judith Lanzinger and Mary Jane Trapp, candidates for Supreme Court of Ohio. We'll return in a few moments for our traditional City Club questions. First, this short break. We welcome you to this City Club Forum, the longest continuously running free speech forum in the country. We hope you will become a member of the City Club and become active in our ongoing civic dialogue. You may visit our website, cityclub.org, for information about upcoming programs and links to our webcasts and podcasts. And today's debate will be especially worthwhile when you go to the polls and vote, or vote by mail ahead of time. Election Day is Tuesday, November 2nd. And now we would like to proceed with the traditional City Club audience question and answer portion. And holding the microphone today is Membership Database Manager Lucille Barbati. Do we have any questions from the audience?
Justice Lanzinger, you have repeatedly stated that judges should be restrained and should not create law, yet Yet you ruled in favor of executive privilege to protect Bob Taft and Tom Noe during the Corngate scandal. Executive privilege has never existed under Ohio law. How does that exhibit judicial restraint?
Okay, first of all, let me clarify something. That case was solely on executive privilege. It had nothing to do with Tom Noe. I want to make that clear because I have never dealt with a case involving Mr. Noe. The executive privilege case was done early in my career on the Supreme Court. And I have to tell you that based on a case that came afterwards, the case involving whether there would be an en banc procedure in the Court of Appeals, meaning should all the judges go together and look at a case if there had been a conflict. In that particular case, I ruled with Justice Cupp in dissent, saying the Constitution did not have that as part of its language. because of that case and the way I really looked at the Constitution, I believe that if I were to go back and look at the executive privilege case, I may actually have voted differently. It is now precedent, though, and I believe in precedent, and I would follow established precedent by the majority. I'm not afraid to say when I make mistakes, and I have done that in my 25 years as a judge. I think it's very important to be intellectually honest and to tell the people who look at your opinions why you rule the way you do.
Do you have a comment, or shall we go to the next question?
Next question.
Anybody? The gentleman?
Yes, I noticed, again, on this subject of what I presume is basically lawmaking by the judicial. There was a case where someone was convicted of speeding, and the Ohio Supreme Court upheld a decision saying that a police officer a person can be convicted by a police officer judging what speed you're going. That seems like it's passing laws instead of making decisions on the law.
Would you phrase that as a question? I'm not. I think what you're asking about is the relationship of the police officer to the final decision.
No, I'm not a lawyer, so I don't know if it's a law in the if it was a law in the state that this could be done, and the Supreme Court upheld it, or whether this was just brought in front of the court, and then the court kind of made a decision that this was a law because they wanted to decide that they're making the laws, and
I think I understand. Judge Trapp?
Well, I am of the opinion that Jenny versus Barberton case is another example of outcome-oriented decision-making by the Supreme Court. Instead of looking at the law and the facts and applying them to the case before you and allowing the decision to flow to the right result, I believe that this was a way of saving a bad case. In law school we're taught that bad cases make bad law. And the facts of that case was the facts were that the police officer and the prosecutor didn't do their homework. They did not bring in the police officer's certificate to show that he was properly trained to use this radar, so they couldn't admit the radar evidence in the case. They only had the officer's estimate of the speed. Now, that can be problematic for people. If you have a commercial driver's license and a police officer estimates your speed and gets it wrong by 1 mile an hour, you could potentially lose your ability to do your job. So that's why this case is of importance to everyone. I agree with Justice O'Donnell's dissent in that case, that the decision, the majority's decision to allow just that estimate of speed without anything further was overbroad and was a bad result.